you ever wondered what would happen if you walked into an embassy and asked for asylum? Could they just protect you forever? Why was Julian Assange holed up inside an Ecuadorian embassy for 7 years? And wait, was that even legal? In today's video, we are going deep into the world of diplomatic asylum using two fascinating real-life cases, the Julian Assange standoff and the lesser-known but legally crucial Haya de la Torre case. We bust common myths, explain what the law really says, and even look at how Indian law sees asylum seekers. So, if you're into global drama, human rights, or just want to know what your rights might be, stay with me. You're going to walk away from this video a lot wiser. What is a diplomatic asylum? Let's start with the basics. Diplomatic asylum is when a person seeks refuge inside the embassy or consulate of another country, hoping that the state will protect them from persecution. Sounds straightforward, right? But here's the twist. Under international law, diplomatic asylum is not a guaranteed right. It's more a matter of custom and political will than a binding legal obligation. This is where it gets murky and controversial. Because while embassies enjoy inviolability under the Vienna Convention on Diplomatic Relations, they are not foreign territory. They are still on the soil of the host country. So, giving someone asylum inside an embassy, this is a legally grey zone. And it's sparked more than a few international standoffs. Let's talk about Julian Assange, founder of WikiLeaks. Hero to some, villain to others. In 2012, he entered the Ecuadorian Embassy in London, fearing extradition to Sweden and possibly to the US. He stayed there for nearly 7 years. Yes, 7 years. Living in a tiny room, no sunlight, no fresh air. Why didn't the UK just storm in and arrest him? Because embassies are protected spaces. Under the Vienna Convention, host nations can't enter without permission. But, and here's the key, the UK didn't recognize Assange's asylum status. They waited. And in 2019, after Ecuador withdrew protection, he was arrested the moment he stepped outside. So, was that diplomatic asylum legal? That depends on who you ask. Ecuador claimed it had the sovereign right to grant asylum. The UK and Sweden disagreed. It was a legal deadlock and a political chess game. Now, rewind to 1950 and the case of Victor Raul Haya de la Torre in Peru. He was a political leader accused of rebellion. He fled to the Colombian embassy in Lima. Colombia granted him asylum, claiming it was within the rights under the 1928 Havana Convention on Asylum. But Peru refused to give him safe passage out of the country. The standoff went to the International Court of Justice, or ICJ. The ICJ ruled that while asylum could be granted, safe passage was not obligatory unless both countries agreed on the nature of the political offence. In other words, you can offer asylum, but you can't force the host country to let them go. This case created the foundation for today's diplomatic asylum debates. What about Indian law? Now, let's bring it home to India. India does not have a dedicated asylum law. Everything operates on an ad hoc basis, governed loosely by the Foreigners Act 1946 and principles of non-refoulement under Article 21 of the Constitution. But here's the interesting part. India has hosted Tibetan refugees, Bangladeshi migrants, Sri Lankan Tamils and Rohingyas, all under different frameworks. Yet, diplomatic asylum has rarely been tested here. If someone were to enter a foreign embassy in India and seek protection, what would happen? In practice, Indian authorities might wait, just like the UK, but would likely not recognize it as a formal right. There's also the Supreme Court judgment in 1991 in Louis De Raedt versus Union of India, where the court held that foreigners have no fundamental right to remain in India, but the government must act fairly and reasonably under Article 21. Let's bust a few popular myths now. Myth 1. Embassies are foreign soil. The reality, embassies are protected, but they remain under the host country's sovereignty. Myth 2. Once you get asylum, you're safe. The reality is, without safe passage or recognition from the host country, you're still stuck, as Assange learned it the hard way. Myth 3. Diplomatic asylum is a right under international law. The reality is not universally recognized and varies by treaties and regional practices. So, what can we learn from all this? Sometimes the law isn't just black and white, it's a spectrum of grey shaped by politics, fear, and courage. Julian Assange's isolation, Haya de la Torre's 5-year embassy lockdown, they show us how freedom, once taken for granted, becomes the most precious thing. And in a world where lines between heroism and criminality are blurred, we must ask, what does justice really mean? Sometimes the greatest prison aren't made of bars but of loopholes, silence, and indecision. If you found this video thought provoking, insightful, or even just sparked a new question in your mind, hit that like button and subscribe for more deep dives into the law, politics, and society. Don't forget to turn on notifications because the next story I'm working on might just be about a law that could affect you tomorrow. And if you've got thoughts about asylum, freedom, or the future of international law, drop them in the comments. Let's have a real conversation. Also check out our full legal guide and global cases playlist for more eye-opening content. The links are mentioned below. Until next time, stay informed, stay empowered, and most importantly, stay curious. Take care. Bye.